Fine. Any doubts right now? No doubts, anyone? All right. Write down the first topic or the next topic. Judiciary and the concept of state in Article 12. Judiciary and the concept of state in Article 12. Judiciary and the concept of state in Article 12. Judiciary and the concept of state in Article 12. All right. So one of the first thing that happens with the fundamental rights is that Article 12 defines what is state. Now there is a one, I think most of you would have already done this, whether judiciary is part of the definition of Article 12 or not. Now, it's never been asked in UPSC mains examination till date. So this is one of those studied topics that I'll make you write so that you're prepared, assuming that it is asked in 2026. But it is a static topic, but it has not been asked till date. So it is an expectation that it can be asked in the future at any point of time as a static question. So write down. First write introduction, 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 introduction. Article 12, Article 12, Article 12 defines state. Article 12 defines state for Part 3, fundamental rights. For Part 3, fundamental rights. For Part 3, fundamental rights. It includes the government. It includes the government, comma, parliament. It includes the government, parliament, comma, government and legislature of each state, government and legislature of each state, comma, all local, all and other authorities, all local and other authorities within the territory of India, or under the control of the government of India, or under the control of the government of India, or under the control of the government of India, under the control of the government of India. In your UPSC answer, you can write it as a bullet point also, that it includes, and you write down parliament, government of state, all legislatures, all local bodies, other authorities, right? Write down. So what would happen is that becomes your introduction. Then you add this line as a second paragraph to the introduction. Write down. The definition of state under Article 12, the definition of state under Article 12, Article 12 is applicable for Part 3, is applicable for Part 3, and for DPSP, in brackets Article 36, in brackets Article 36, brackets Article 36. You don't need to remember the article, but I'm just making you write this so that when you're trying to revise, you know which article to look at. You can just say the DPSP also. So Article 36 also ends up saying that unless the context otherwise requires, the state would have the same meaning as Part 3. So the definition of the state in DPSP and therefore in fundamental rights also is the same. right? So you first start with defining Article 12, then you add small line that it also has a similar same meaning within DPSP. This part is clear to everyone? All right, write down. Judiciary under Article 12. Judiciary under Article 12. Judiciary under Article 12. Judiciary under Article 12. Under Article 12. In the, write down bullet points, in the A dot R dot Antulay, 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 case 1984. Antulay, in the A dot R dot Antulay, Antulay, Antulay case 1984, 1984, the Supreme Court has said that judiciary is not a state under Article 12. Judiciary is not a state under Article 12. Judiciary is not a state under Article 12. However, judiciary is still subject to the Constitution. However, judiciary is still subject to the Constitution. Is still subject to the Constitution. Subject to the Constitution and must uphold constitutional principles and must uphold constitutional principles and must uphold constitutional principles and must uphold constitutional principles. I'll tell you what the primary issue is with this definition of state. So what happens is you have the fundamental rights. Article 12 defines what is a state. Now, the argument has been made is that is the writ jurisdiction for violation of the fundamental rights actually applicable to the judiciary? I'll give you, there's a famous case that ended up happening, I think 68, I'm forgetting the name of the case itself. Let's say you take, let's say Ranveer Ralabadia's case, it's hypothetical. Let's say the Supreme Court ended up putting a gag order on him. Is he allowed to put a writ against the Supreme Court that the Supreme Court is violating my freedom of speech? You get the issue? Let's say the police has put a, let's say, violated the freedom of speech and expression for an individual. Then you can approach the High Court or Supreme Court for writ jurisdiction that my fundamental right or Article 19, Clause 1, Clause A is being violated. Let's say the Supreme Court or the High Court themselves have put you a gag order. Then can you apply a writ jurisdiction against the Supreme Court that the Supreme Court has violated your fundamental right? You get the issue? So it is only applicable to those that have been defined under state. And for the Supreme Court, this has become an issue that they continue to say that as when we're fulfilling our judicial functions, we're not the writ jurisdiction would not be applicable to us. I'll explain this. You first write down the cases. I'll explain case by case. What is your district courts would be done by the high courts only, no? So the writ jurisdiction is only applicable to Supreme Court and High Court. So the district courts would not come into the picture. If, let's say, a district court has put up a particular order, the view of the Supreme Court is, let's say the Supreme Court has basically said a judgment. And in that judgment, they have put a gag order. You cannot ask for a writ jurisdiction that the Supreme Court has violated your freedom of speech and expression. What you need to do is file a curative petition. A curative petition, or in this case, is that, all right, there is a particular order that has been given against me. Can you please look at it? And can you please tell me a cure to this problem? So they end up saying that the judiciary, therefore, technically, cannot violate your fundamental rights. Supreme Court is also able to make laws under which article? 141. 142 is complete justice. 141. So any law or any judgment that is passed by the Supreme Court is law. Everyone has to follow. So this is known as judicial legislation. This will do when we get to the judiciary part. The argument is, can a law or can a judgment that has been passed by the judiciary, which is now seen as a law, can it violate a fundamental right? Let's say the parliament passes a law and you end up saying that it violates, let's say, Article 19 or Article 14 or Article 15. You can approach the Supreme Court under writ jurisdiction and try to declare this to be null and void. Can be done. That it violates my freedom of speech and expression. It violates Article 14. But can a judgment of the Supreme Court violate a fundamental right? I'm only telling you what the problem is. Once we go through the Supreme Court judgments, you'll understand what the solution is. But you get the primary issue with this, right? If the Supreme Court is state, then it is applicable to the writ jurisdiction. If it is not state, it would not be applicable to the writ jurisdiction. Write down. In the Rupa, RUPA, in the Rupa, RUPA, Rupa Ashok, ASHOK, Rupa Ashok, Rupa Ashok, Hurra case, HURRA, Hurra case, HURRA, Rupa Ashok, Hurra case, 2002, the Supreme Court has said that when they're performing their non-judicial function, they fall within the definition of the state. They fall within the definition of the state. However, when they are performing their judicial functions, then they do not fall in the scope of state. And write down the next case. In the Riju Prasad Sarma case, Riju, RIJU, Riju Prasad, PRASAD, Riju Prasad Sarma, SARMAH, Sarma, 2011. The court has clarified that the judiciary is performing administrative or quasi-judicial functions. Then the writ jurisdiction is applicable. Writ jurisdiction is applicable. You write down one example for this. Article 145. You write down one example for this. Article 145, rules of court. Article 145, rules of court. Article 145, rules of court. You don't need to remember the article. If you only say rules of court, that would be enough. This is only for your reference. I'm making you write the article. Article 145, rules of court. However, when it is acting in judicial capacity, However, when it is acting in capacity, judicial capacity, it cannot be regarded as a state. It cannot be regarded as a state. It cannot be regarded as a state. Cannot be regarded as a state. Cannot be regarded as a state. Therefore, 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 judiciary's status, therefore, judiciary's status under Article 12, therefore, judiciary's status under Article 12, therefore, judiciary's status under Article 12 depends upon the nature of its actions. Depends upon the nature of its action. Depends upon the nature of its action. Depends upon the nature of its action. Nature of its action. Of its action. So, what it means is that under Article 12, you have the judiciary. Within this, you end up saying when it is performing non-judicial functions, particularly administrative, it is state, right? So the example here you can give is rules of court. But when it is performing its judicial function, then it is not a state, right? If you only draw this in a UPSC examination, that is also fine, but you also do need to mention the case laws. I'll explain what the primary issue is here. I'll give you the example that I use in the foundation class also. What is habeas corpus? To bring the body off. So if somebody has been put under false detention, the High Court or the Supreme Court can ask for that individual to be brought in front of them. So this is generally sometimes used in cases where a girl or a boy run away from family to get married. What would happen is the parents' family would file that my daughter or my son has been kidnapped. Then what would the court do? They would file a writ of, or they would issue a writ of habeas corpus that you bring this girl to me. They would ask the girl, have you run away or have you been kidnapped? If she's of 18 years of age and has proper mental capacity, the court would say it is not a problem. You have not been forcibly detained. That is the core idea of habeas corpus. It is against both the citizen and against the administration. So if police has put you in jail and they're not able to justify it, the writ of habeas corpus would be issued in relation to this. You get the core idea of this. Let's say the Supreme Court or the High Court gives an order to put you in jail. They have given a judgment to put you in jail. Fine. Can you file a writ of habeas corpus against the judgment of the High Court? That the High Court has illegally detained me in jail. You get the issue? Can the courts illegally detain? Yes or no? You get the issue of this, right? High courts also pass an order that you put this person in jail. Supreme Court also passes an order, you put this person in jail. Police also puts you in jail. Against the police, you can file a writ of habeas corpus. But when the High Court says you put person in jail, can you file a writ of habeas corpus against the High Court? That have been illegally detained by the High Court. Have you ever heard of this? No. Why? Because it is a judicial function. The writ jurisdiction would not be applicable to the courts when they are performing their judicial functions. The writ jurisdiction would not be applicable to them. You cannot file a writ of habeas corpus in this situation. What would you file? Curative petitions, review petitions. So what would happen is you can appeal the decision of the High Court in the Supreme Court, not by filing a writ of habeas corpus, but by filing a petition, review petition or curative petition. You get the issue of this? You get the, who has not understood, let me know. Because this is basic also, this part of foundation, but this is one question that is going to be asked at some point of time in main exam. When it is asked, I can't predict, but it would be asked. If you don't understand, then you draw this Rotland the 3 Supreme Court judgments and you write it in the answer, that would also be enough. But the core idea of state is that it would not be subject to writ jurisdiction when it's performing its judicial duties. Any doubts on this? Let's say I'll give you an example. One of the things, what is with Article 32? That it is a violation of fundamental rights. You can file a writ. Let's say the CJI has transferred one judge from one place to the other. Can you say that it violates Article 14? That was arbitrary. Is it, that's what is it administrative? If one judge is transferred from one place to the other, or let's say the Supreme Court through the collegium system ends up saying that this person should be appointed to the Supreme Court, can you file a writ that it violates Article 14, that it is arbitrary or it is unreasonable? Like you and I can file. Can you and I individually file this case? No. It's a judicial function. It's not an administrative function. They have said that it is a judicial function. Administrative functions are rules of court. Like you have people that are working in the Supreme Court, the timings, all of this. So you have Article 143. What article I made you write? 145. Hmm. So what it does is that the Supreme Court, with the approval of the president, can give out rules of court. It would include things like the persons practicing before the courts, like advocates, senior advocates, those type of classifications. Rules pertaining to hearing of appeals, rules in pertaining to enforcement of fundamental rights, meaning how the cases would be filed, which judge would be allocated to which cases. All of these are generally rules that have been mentioned of the court. These are administrative functions of the court. So as far as the judicial functions are concerned, the writ jurisdiction would not be applicable. But as long as their administrative functions are concerned, the writ jurisdiction would be applicable. You get this conceptually? Let's say Supreme Court passes a judgment. We end up saying that that judgment is law. They passed Keshananda Bharti. Can we say it violates Article 14? That is arbitrary. Can you file a writ that it violates Article 14? No. Why? Because you're not allowed to. When the judiciary is acting as in its judicial function, it is not a state. If you end up saying that it is state, then it becomes party to a writ jurisdiction. This part is clear to everyone? All right. Like in terms of transfer and all of this, yes, but the Supreme Court in itself would decide all of that. Supreme Court would in itself decide all of that. It is quasi-judicial, but Supreme Court would decide which is judicial function and which is administrative and quasi-judicial. So that they have done multiple times in the past. Like recently, it was with the CJI, that the CJI would give out cases. In the sense, he is the master of the roster. Is it an administrative decision or a judicial decision? So then can you file a writ in relation to this, if it is administrative? You get the issue? Right. All right. Write down separately. Separately. Other authorities. Other authorities. Other authorities. Other authorities. Other authorities. Other authorities. Now, what happens is the Supreme Court or the court in itself is not directly mentioned in Article 12. The argument is it part of what is known as other authorities? It is not. When it is functioning in its administrative functions, it is state. If it is in judicial function, it is not state. But what are other authorities that also can be asked in UPSC mains? So write down. The Supreme Court in the Rajasthan State Electricity Board case, the Supreme Court in Rajasthan State Electricity Board case, 1967, 1967 has held that the expression other authorities is wide enough to include all authorities created by the Constitution. To include all authorities created by the Constitution or statutes. By the Constitution or statutes. STATUTE. Statute. It is also not necessary that the statutory function statutory authority should be engaged in undertaking governmental or sovereign functions. Like if I were to ask you, is BCCI, all of you have heard of the BCCI case? Is BCCI state? No. Why? Because Supreme Court under this Article 12 ended up saying when you include other authorities, it does not include BCCI. That has been the view of the Supreme. What about NCRT? Is NCRT state? Is it a government body? Is NCRT a government body? Because if it's a government body, then it would be applicable to which jurisdiction? If BCCI was a state under Article 12, then it would be applicable to which jurisdiction? So court has also taken the view that NCRT is also not state. So write down separate paragraph. The Supreme Court has laid down several tests or guidelines for deciding other authorities. Under Article 12. For deciding other authorities under Article 12. It has laid down guidelines. Write down in bullet points now. It has laid down guidelines. Write down in bullet points. First, R.D. Shetty case. R.D. Shetty. R.D. Shetty. SHETTY. Shetty case, 1979. Next to it, write 5 principles. Just do one thing, just only write R.D. Shetty case. Write down the second one. Ajay Hasia case. AJAY. Ajay Hasia. HASIA. Ajay Hasia case. and in brackets write down society. 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 So the argument was that if things are created under the Society Act, are they state or not? This is the famous BCCI case. BCCI is actually created under the Societies Act. Now the argument is that in the Ajay Hasia case, I'm not going to talk about the principles that they've laid down. That is not necessary for GS. They've laid down various principles on the basis of which you can decide whether a society which has been created under the Societies Act is state or not. Whether they take money from the government of India, whether they have been created by a statute of the government of India, there are a lot of principles that they have laid down. Tested on this principle, they ended up saying that BCCI is not a state. So any society that, if you want to make the argument, is state, would have to follow what is known as the Ajay Hasia test. This part is clear to everyone? Write down the next one. Chandra Mohan Khanna case. Chandra Mohan Khanna case. Chandra Mohan Khanna case. Chandra Mohan Khanna case. In brackets, write autonomous body. Autonomous body. Autonomous body. Autonomous body. Autonomous body. So the example here would be BCCI. The example here would be NCRT. Don't write the example, I'm just explaining it. Like in UPSC, you don't want to like over explain something. Here they ended up saying BCCI is not a state under this test. Here they ended up saying NCRT, which is an autonomous body, even though it is created by an act. It is created by a statute. They ended up saying that we have laid down certain criteria under CM Khanna. And under this case, NCRT is not a state. You get this conceptually? So you cannot file a writ against NCRT. Try down. At least in some cases, you cannot file a writ. Pradeep Kumar Biswas case. Pradeep Kumar Biswas, BISWAS. Pradeep Kumar Biswas, BISWAS case 2002. 2002. Next. Federal bank case. Federal bank case. Federal bank case. 2003. Federal bank case. 2003. In relation to private financial institutions. In relation to private financial institutions. In relation to private financial institutions. Relation to private financial institutions. So what they were trying to do was file a writ against the federal bank. The court ended up saying the federal bank is not a state. But they also laid down various tests. That this is a test to decide whether a private financial institution like HDFC or all of this, whether they are state or not. Right on the next one. SS Rana case. SS Rana case. SS Rana case, 2006, in relation to cooperative societies. In relation to cooperative societies. Relation to cooperative societies. Cooperative societies. And write down the last one. Write down the spelling. SATI, MBLA. SATI, MBLA. Sharma case, 2011. Sharma case, 2011. 2011. Unaided minority schools. 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 This is some of the examples that I've made you write. So Supreme Court has, in all of these cases, has laid down various tests to test whether these type of institutions, whether they are state or not. You only write the case, you write what they are used for, and that would be enough in the UPSC examination. There are other multiple cases also where they have done for other aspects. Even if you remember 2 or 3 of them, you write that many in your UPSC answer, it would be enough. This part is clear to everyone? Any doubts? Write down the next topic. Reasonable classification. Reasonable classification under under Article 14. Reasonable classification under Article 14. Reasonable classification under Article 14. Reasonable classification under Article 14. The next topic. There are no doubts on state, right? इसमें conclusion नहीं होगा. You can't give any way forward. The best is they ask whether it is or not. You don't want to say that it is or it should be. There is one line that NCRWC, the National Commission to Review for Working of the Constitution, ended up saying that you amend Article 12 and you add a particular line there. So maybe judiciary may fit in there. But it's too far-fetched. And judiciary is not going to ever accept it. So in certain cases, you cannot give a way forward. So in GS, you cannot give a way forward in this particular aspect. So you leave it at B. The best you can do is maybe provide a summary of what you have ended up writing. This part is clear to everyone? Reasonable classification under Article 14. Write down introduction. Article 14 provides equality before law. Article 14 provides equality before law and equal protection of law. Article 14 provides equality before law and equal protection of law. Equality before law and equal protection of law. So, equality before law were borrowed from which British origin, right? Why so much? Equal protection of law were borrowed from? Were borrowed from? So why did somebody say Japan? All right. Write down. Equality before law is of British origin. Equality before law is of British origin. Is of British origin. While equality or while equal protection of law, is borrowed from the American Constitution. While equal protection of law is borrowed from the American Constitution. It's borrowed from the American Constitution. American Constitution. American Constitution. Equality before it is negative concept and equal protection of law is a positive concept. Why is equality before law negative? It restricts state from all right. And why is this positive? What is the obligation on the state? No. Treat everyone equally as equal. Yes. You're near, but that's not. You're around the. What is the obligation on the state? And treat unequals. All right, write down. I'll explain the difference. You were saying something? So the affirmative actions would be the example why it is positive. But what is the obligation on the state? Right on. Who said? That's an example. That's a consequence of it being positive. But why is it positive? That I'll make you right. Right on. Equality before law. Equality before law means absence of special privileges. Means absence of special privileges. Absence of special privileges for any particular person. Absence of special privileges for any particular person. Absence of special privileges for any particular person. Any particular person. Any particular person. While equal protection of law, while equal protection of law signifies, while equal protection of law signifies that like should be treated alike, signifies that the like should be treated alike, like should be treated alike, and the unlike can be treated differently. And the unlike can be treated differently. And the unlike can be treated differently. Unlike can be treated differently. Unlike can be treated differently. So why is it negative? Because it puts a restriction upon the state. What is the restriction upon the state? No special privilege. That the state is not going to give any special privilege to anyone. Whether you're the president or whether you're the common person, everyone would be treated equally in front of the law. If the law says that the penalty for not wearing a helmet is 500, so whether you're the president or a common person, everyone has to pay 500. But we know that there are exceptions. So those exceptions also have to be made in law. But that is the core reason why it is negative, because it puts restriction upon the state. What is the restriction? No special privilege to any person. This part is clear? That is the obligation in the equal protection of law. That the like should be treated alike and the unlike should be treated differently. Like, I'll give you an example for this. Let's say if there are 3 people that have been asking for bail. Let's say I have asked for a bail. Then there is a pregnant woman asked for a bail. There's an old person that has asked for a bail. All of us have committed the same crime. Equality before law would say that all 3 of us would get bail or none of us would get bail. It's negative in nature. No special privilege, irrespective of the fact that one person might be pregnant or the other person might be old. Equal protection ends up saying that the unlike can be treated differently. Are the 3 like each other? Are all the 3 same? Yes or no? They're different, and therefore they can be treated differently. Equal protection of law allows for positive discrimination. If you only have equality before law, you would not have positive discrimination. Why? Because you cannot discriminate at any point of time. Because that is the core essence of equality before law. But when we talk about equal protection of law, equal protection ends up saying that you can see 2 people differently. You can treat them differently. So it allows for positive discrimination. This part is clear? Reasonable classification therefore flows from this. If you had only equality before law, you cannot have classification. No? Everyone has to be treated equally. Everyone has to be treated same. So there is no point of classifying anything. Why? Because you're not going to give any special privilege or penalty by classifying. So reasonable classification actually comes out of equal protection of law. You get this conceptually? Just draw this in a little neater sense. Equal protection of law, positive. What is the obligation on the state? To treat unlike differently, which is an aspect of positive discrimination. This part is clear to everyone? I hope I'm not wasting anyone's time because all of you are maybe aware of all of this. I know this is basic foundation, but I'm assuming that this is helping you understand the concepts much more clearly. Like if the any time positive negative is used, you can actually make the sense on the basis of obligation and restrictions. Any doubts on this? You're able to now link equal protection of law to reasonable classification. Do you understand on how the linkage is made to reasonable classification? Any doubts? All right. This becomes your introduction. If you want, the question is only on reasonable classification, then you can only say about equal protection of law, and that would be enough. Write down. Aspect of reasonable classification. Aspects of reasonable classification. Aspects of reasonable classification. Aspect of reasonable classification. Aspect of reasonable classification. All persons are not born equal by their nature, are not born equal by their nature or circumstances. By their nature or circumstances. By their nature or circumstances. Therefore, such person requires separate treatment. Therefore, such person requires separate treatment. Therefore, such person requires separate treatment. Separate treatment. Therefore, the legislature can make laws. Therefore, the legislature can make laws to distinguish, classify, to distinguish and classify and select, to distinguish, classify and select persons and things. Persons and things. And things. Article 14 permits classification. Article 14 permits classification. Article 14 permits classification. It is a systematic arrangement. It is a systematic arrangement. It is a systematic arrangement of persons and things, of persons and things, of persons and things under a definite scheme. 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 Right? So this two paragraphs that you have written, it is a conceptual understanding. It may or may not be completely required in a mains examination. But this helps you understand what do we mean by reasonable classification. Right? So it is a conceptual understanding of reasonable classification. Write down. Polity perspective. Polity perspective. This is what you write in the mains answer. Polity perspective. Write down. The Supreme Court in the Anwar Ali case, the Supreme Court in the Anwar Ali case, ANWAR, Anwar Ali case, 1952, gave a test for reasonable classification. Gave a test for reasonable classification. Gave a test for reasonable classification. Reasonable classification. Reasonable classification. The classification must be on the basis, of intelligible differentia. Must be on the basis of intelligible differentia. intelligible differentia. Must be on the basis of intelligible differentia. It must have a nexus. It must have a nexus with the objective being sought. It must have a nexus, NEX, US, nexus with the objective being sought. Must have a nexus with the objective being sought. Must have a nexus with the objective being sought. What it sought? SOUGHT. Right? Objective being sought. So intelligible means intelligent, differentia meaning difference, and objective to all of you understand. What happens is, if you have classified people into various categories, it should be intelligent. When you end up classifying a group of people into various categories, who would decide whether it's intelligent? Court. But I'll give you the biggest, one of the examples for this. One is reservation. You have divided general, scheduled caste, scheduled tribe, OBC, EWS, PWDs. These are all the classifications that you find in the reservation policy also, let's say for the UPSC examination also. It's a classification of people into different categories. You have to look at whether it is intelligent. So what is the reason of this, what is the criteria being used for this differentiation? What is the criteria? So historical discrimination on the basis of caste, historical discrimination on the basis of tribal status, economic, again historical discrimination on the basis of, or economic backwardness on the basis of caste, and disability. Can you make a distinction between all of them in an intelligent manner? Can you distinguish a person who has been historically discriminated on the basis of caste from somebody who may belong to a general category? Can you make a distinction? Right? So you can look at various communities that have been historically discriminated. You have a list of those communities from ancient texts, from the Mandal Commission, from the 1931 survey also, that these were the scheduled caste, that these are the tribal groups that have been historically discriminated. In the EWS, you laid down a criteria that if you have this much income, your parents have this much income, if you have this much land, you would be EWS. In the OBC, in the Swanee case, ended up laying down 20 guidelines to get OBC status. Then there was guidelines that were given also for creamy layer, that if you do not fall into this, then you're part of the creamy layer. Within PWD, you also have PWD 1, 2, 3. They're also decided on the basis of, let's say, your eyesight, your hearing, your physical disability. So what happens is, have you been able to differentiate between all of them on an intelligent manner? If no, then would be declared null and void. If you have been able to do this in a manner that the Supreme Court is able to say that it is intelligent, then yes. The most famous case would be the next topic that we pick up, which is Jat reservation and the Maratha reservation. One of the thing is, I'll make you write this in the next topic, is on the basis of reservation, you have this concept of a backward class. So you have in Article 16, the mention of backward class, SABC, socially and educationally backward class. In the Chitralekha case, the Supreme Court has laid down a parameter that who can be declared as a backward class. They ended up saying economic backwardness, educational backwardness, low education, and further Article 16 also says low representation. So 3 have been given in the Chitralekha case, 1 is given in Article 16, that you're not adequately represented in government services. So 4 criteria are there. In the Ram Singh case, 2015, the Supreme Court turned down the Jat reservation. They ended up saying you do not, making Jat OBC is not intelligible. It's not reasonable. Are Jars economically backward in Haryana? Are they underrepresented in government services? Are they educationally backward in the sense compared to other communities in Haryana? Then Supreme Court said it is null and void. Same thing happened with the Maratha reservation. So that case happened last year, 2024, the Patil case. They were given OBC status. Supreme Court said, are Marathas backward? Are they economically weaker? Are they underrepresented in the state of Maharashtra? No, null and void. So what happens is, if it is not intelligible, it would be declared null and void. You get this conceptually reasonable classification? You understand intelligible differential? Whether it is intelligent or not, Supreme Court would decide. What is the criteria that you have ended up using? So sometimes Supreme Court says, conduct a census, conduct a survey, find out what is the parameters here, and on that basis, you give the reservation. So when the Jars were given reservation, they did not conduct a survey. So learning from that, when the Marathas were given reservation, they did conduct a survey. But Supreme Court still declared it to be null and void. Because they said that you do not still fulfill this criteria. This part is clear? We'll again talk about this topic in the next topic, which is backward class. The Muslim reservation. Same thing. So what had happened is that Muslims in Karnataka were given reservation. The Supreme Court declared it to be null and void. What the Karnataka government ended up doing is they ended up saying that all Muslims are OBC in the state of Karnataka. The Supreme Court's view was, how can all Muslims be backward? There must be some castes that are backward and some would be forward. So you need to make a reasonable differentiation. You have made zero differences. It's not even intelligible. The same thing happened in West Bengal. West Bengal also gave Muslims reservation, which was turned down by the Calcutta High Court. But they only gave certain communities. The Calcutta High Court's view was, what is the survey that you have conducted that these are backward and those are not backward? So you need to show me that what is the intelligible or what is the survey, what is the criteria that you've done to make them OBC and not others. This one conceptually is clear to everyone? Any doubts on this? So reasonable classification is very important when we do the next topic, which is backward class. But you get the basic understanding of this? Write down. Second thing, the second part, which is the nexus. Why are you making the classification in the first place? You need to show the direct objective. Meaning, let's say you have made this classification, and what is the privilege that you're providing them? Government jobs. So you need to show that whatever privilege that you're providing them, it has to directly help. Because they have low representation. To ensure social justice, that is why reservation has been provided. So let's say when you go for a toll tax, you have a huge list there, no? That this person doesn't pay a toll tax, this person doesn't pay a toll tax. That is also a classification. That these people do not have to pay a toll tax and everyone else do. So what is the intelligible criteria there? It's done, right? Is it done or not done? There is a classification that some people don't have to pay toll taxes and some, but everyone else has to. So a criteria has been made that these are the ones, like if you won the Bharat Ratna, you're the president, or you're this, that you don't have to pay toll taxes. What is the objective that you're trying to achieve from this? All right. So I don't want to get into that particular case, but the court has said that it is not really a problem. But the end of the day, if you have made a classification, and if you're going to give them any privilege or any penalty also, it has to be seen in terms of the reasonable classification. You've heard of the Bachchan Singh case? What was the Bachchan Singh case? Rarest of rare cases, the death penalty would be given. Now, the idea is, this is also a classification. That these people who have committed a crime would not be given the death penalty, but these people that have committed a crime would be given death penalty. So what is the intelligible differential that the court has used? the crime itself, how heinous the crime is, and what is the privilege, or in this case, the penalty the person is going to get? Death penalty. You get this? So in the Bachchan Singh case also, when you talk about the rarest of rare case, the same argument was used. This part is clear to everyone? Write down. Features of reasonable classification. 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 Reasonable classification. Write down. In the Chiranjit Lal Chaudhary case, in the Chiranjit Lal Chaudhary case, 1951, Chiranjit Lal Chaudhary case, 1951, the Supreme Court has said, in the Chiranjit Lal Chaudhary case, 1951, the Supreme Court has said that the law would be constitutional, that the law would be constitutional even if it is applied to one person or one group of person, to one person or one group of person, to one person or one group of person, one person and one group of person, one person or one group of person. So I'll give you an example. Let's say you have people in India that may suffer from a particular genetic disease. There might be maybe 7-10 people in India that might suffer from that disease. If the government of India gives them free insurance, if the government of India gives them free health care, it would still be reasonable. You have classified them differently, but it is intelligible that they suffer from a particular disease. Even if it only gave privilege to one person, it would still be considered valid. When you talk about any welfare scheme in India, the welfare scheme also has a reasonable classification that these people would get BPL benefits, these people would not get benefits, these people would get scholarship, these people would not get scholarships. There has to be intelligible difference. And whatever that you're giving to them, the classification should match it. Let's say if I end up saying that all sons and daughters of Class A officers can directly go to the interview round. All son and daughters of Class A officers can directly go to the UPSC interview round. It's a classification. It's a classification, but is it intelligible? Further, what is the objective that you're trying to achieve here? The Supreme Court would then declare it to be null and void. Why? Because it does not make direct nexus with the objective that you're trying to achieve. What is the objective? Is give privilege to more privilege. That is not allowed in India. So I'll make you write this. It's a separate case altogether. That in India, you cannot give privilege to more privileged. You ask me. Yeah, definitely. I'm just giving this as a hypothetical example. But yes, it can be done. Right on the next case. The Supreme Court in the Babu Rao case, BABURAO, Babu Rao case, 1954, has said that Article 14 has said that Article 14 does not include the state, in the definition of person. Therefore, the state can be treated with exception. Therefore, the state can be treated with exception. Therefore, the state can be treated with exception. Treated with exception. So in Article 14, you have that the state shall not deny to any person equality before law and equal protection of law. What does the word person mean? Does it include citizens, aliens, and foreigners, aliens? What else? There is a third thing that is in the definition of person. What is that third thing? It, that is not what I'm looking for. Aliens include foreigners. Aliens means both friendly aliens and enemy aliens. Friendly aliens are foreigners in that context. Legal persons. So the definition of person in Article 14 has three aspects. You have citizen, you have alien, but you also have what is known as legal person, meaning things that have a legal identity. Let's say if there is a company that has been formed under the Companies Act, it is a legal person because it has a legal identity. Let's say there is a society that has been formed under the Societies Act, it is a legal person. Therefore, Article 14 includes all three, including a legal person. Now, what the Supreme Court has ended up saying, that under the definition of person, it does not include state. The state is not under the definition of state or under Article 14. So what it means is that when you talk about equality before law, equality before law ends up saying that you cannot give any special privilege to any person, but you end up saying that person doesn't mean state. So therefore the state can be given exceptions, state can be given privileges. So the biggest example of this is, let's say you had Air India when it was a government company, right? It was continuously bailed out by the government of India. It was continuously, when it was a government company, completely bailed out. During this period of time, Kingfisher went bankrupt, Air Deccan went bankrupt, Jet Airways also went bankrupt. Multiple airline companies went bankrupt in India, but none of them were bailed out. Technically, what happens when you say when you talk about a legal person and there are any two companies, what would happen is if the government ends up giving one privilege to this company, the other company can file a writ and say that I'm also this legal person, that you need to give me this privilege also. Here, what would happen is, because Air India was state, you can continuously bail it out. And none of these companies can go to the Supreme Court and say that Article 14 has been violated, that I should also be treated in the same manner as Air India was treated. That is why when you become an IAS officer, you're also part of the state, IPS officer as part of the state. You and I, therefore, can be treated differently. You'll get a home and you'll get a lot of things, but you'll get certain accesses, like not paying toll taxes. Why? Because you're the state. And therefore, you can be treated in an exceptional manner. You get this conceptually? Here the state would have? No. That is why it had to be a Supreme Court judgment. No? Here the state would not be under Article 40. It can be treated differently. That is what the intention is. Any doubts on this? You get it conceptually, right? Write down the next one. The Supreme Court, in the Dalmia case, Dalmia, Dalmia case, 1958, in the Dalmia case, 1958, has also stated that Article 14 forbids class legislation. Article 14 forbids class legislation or improper discrimination that privileges the elite. That privileges the elite. So when the Supreme Court is using the term class legislation, you have to take into the context of 1950s. When it is saying class, what it is trying to mean is elite class. So what had happened is in a lot of countries that got independence at that time, they used the state resources to give themselves more privileges and their families more privileges. Supreme Court in India ended up saying that this cannot be done. You cannot have class legislation. So the example that I gave, no, class A officer, their son and daughters being directly sent to the interview. You cannot give the elite more privileges. Okay? It would break the nexus on the objective that is being sought. Generally, what is generally the objective? You look at the preamble. That is what the Supreme Court uses for interpretation. Is it improving social justice? Is it improving economic justice? Whether it is improving political justice. So this idea was used. You made a particular classification that in these seats, it would be reserved for women, scheduled caste and scheduled tribes, and these seats would be open. It's a classification. So the Supreme Court ended up saying that this is allowed. Why? Because the objective is social justice. This part is clear. When I talked about the Janit Abhiyan case, where the Supreme Court said EWS reservation is fine, it's a classification that one is EWS, the other is not. The EWS reservation is fine. Why? Because it allows for social justice. That is the objective that you're trying to sort. You get this conceptually? You're able to link things together now, like the preamble with 14 reasonable classification and all of this. That is what is generally required in a UPSC mains examination. That to some extent you're able to do this. Write down. Further, the Supreme Court stated in the same case, further the Supreme Court stated that the classification would be presumed to be constitutional, that the classification would be presumed to be constitutional, presumed to be constitutional, presumed to be constitutional, presumed to be constitutional, and it has to be reasoned, and it has to be reasoned for unconstitutionality, and it has to be reasoned for unconstitutionality, and it has to be reasoned for unconstitutionality, 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 unconstitutionality. Meaning, if the government of India, any state government or union or any otherwise, make any classification, the Supreme Court and the High Court are going to presume that it is constitutional, that it is intellectual differentiate. The objective is completely clear. It is therefore the job of the petitioner to make the argument that it is unconstitutional. So the burden of proof lies on you and not on the state to prove unreasonableness. Do you get this conceptually? So when the EWS reservation was passed, the petitioner, which was Janit Abhiyan had to make the argument that it is unconstitutional. So the CA case that you ended up asking, All India Muslim something case is there. It is still pending in the Supreme Court. But they are the ones that are trying to say that this classification that you have made, that these minority communities from these three countries, it is reasonable. They have to prove that it is unreasonable. When they try to prove that it is unreasonable under Article 15, the Supreme Court, by and large, in their oral judgment, has ended up saying that it is only meant for citizens. You get this conceptually? Right? Write down. Examples. 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 Write down. Examples. Write down. Deaf Employee Welfare Association case. Deaf Employee Welfare Association case 2014. 2014. Welfare Association case 2014. 2014. Janit Abhiyan case 2022. Janit Abhiyan case 2022. Janit Abhiyan case 2022. Indra Swani case 1992. Indra Swani case 1992. Indra Swani case 1992. 1992. Multiple examples are there. It's just continuously, like the Maratha agitation was, the Patil case was also on this, the Ram Singh case was also on this. You write down few examples, it would be enough. Like in the Swani judgment case, they ended up saying that OBC reservation is valid. It's a reasonable classification. In the Janit Abhiyan case, they ended up saying that the EWS classification is valid. In the deaf employee case, they ended up saying it's invalid. What had happened is that you had the railways. Railways ends up giving a PWD card that allows people with disabilities to travel free and at sometimes travel for a minimum amount of fare. They ended up saying, the railways, that it would only be given to those that are blind and not to those that are deaf. Because it was only the blind that have a problem when traveling in the railways and not the deaf. The Supreme Court said that this is an unreasonable classification. You cannot make this kind of differentiation between the PWDs. So they said this is unreasonable. Conceptually, this part is clear to everyone? You're able to write the examples also? Just write down one last line as a conclusion. Conclusion. Reasonable classification must be reasonable classification must not be arbitrary, artificial, or evasive. EVASIVE. Or evasive. 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 This part is clear to everyone, right? Reasonable classification, everyone understands? No doubts on it? All right. Write down the next topic. Equality, or Article 14, write down the next topic. Article 14 strikes at arbitrariness. Article 14 strikes at arbitrariness. Article 14 strikes at arbitrariness. Arbitrariness. Article 14 strikes at arbitrariness. This is one of the most often used. Reasonable classification plus arbitrariness. Like, I think when you do foundation, you sometimes hear the line, when Article 31C comes, Article 14 goes out. It has to do with this issue. Write down. The Supreme Court in the E.P. Royappa case, E.P. Royappa, ROYAPPA, Royappa case 1974, developed this doctrine. The Supreme Court said that Article 14 protects against arbitrary actions of the state. Protects against arbitrary actions of the state. Arbitrary actions of the state. Including executive and legislature. The Supreme Court in the ADM Jabalpur case, the Supreme Court in the ADM Jabalpur case, Jabalpur, Jabalpur case, 1976, 1976, has said that rule of law, has said that rule of law under Article 14, has said that rule of law under Article 14, rule of law under Article 14 is the antithesis, antithesis, antithesis to arbitrary actions, arbitrary actions. It ensures fairness, and equality of treatment. It ensures fairness and equality of treatment. Equality of treatment. Right. So I'll explain what it means. All of you remember the Menka Gandhi case. The Menka Gandhi case happened in relation to Article 21, where the term due procedure established by law was changed into due process of law. But if you look at the original case, what had happened is that Menka Gandhi's passport was taken away. And the fear in Indira Gandhi was that Sanjay Gandhi had died, that she would, and she had left Indira Gandhi's house, that she would take her Varun Gandhi away from India to a foreign country. So what the Indira Gandhi government indirectly did was take away her passport. And they ended up saying this was done in national interest because that was allowed under the Passport Act. The Supreme Court said that this is an arbitrary action. What you have done, that this is not reasonable. And they ended up saying that taking away her passport violates Article 14. Why? Because the action is arbitrary. There's a very famous case known as the Dalbir Singh case. I'll make you write that as the example. What had happened is that under the Arms Act, it ends up saying that if somebody uses a firearm, they would be given the death penalty. If you use a firearm, you would be given the death penalty. When I say use firearm, does it mean I am holding it in your hand? If I shoot it during wedding celebrations, is it a use of firearm? If I shoot somebody in defense, is that a use of firearm? Or if I shoot somebody just for the sake of murdering somebody, is that a use of firearm? So what would happen is, if somebody shoots it in the air during wedding celebration, that person can also be given death penalty. So what the Supreme Court ended up saying, that the word use is arbitrary. The word use is arbitrary. It can be misused. And therefore, they declared it to be null and void. They said that it violated Article 14. This part is clear to everyone? Any doubts on this one? Write down. Examples. Menka Gandhi case. Menka Gandhi case. Menka Gandhi case. In relation to the Passport Act. In relation to the Passport Act. Menka Gandhi case in relation to the Passport Act. Passport Act. Second, Dalbir Singh case. Dalbir Singh case. Dalbir Singh case. DALBIR. Dalbir Singh case. 2012. Dalbir Singh case 2012 in relation to the Arms Act. In relation to the Arms Act. In relation to the Arms Act. Joseph Shine case 2018. Joseph Shine case 2018. Joseph Shine case 2018. Navtej Singh Johar case. Navtej Singh Johar case. NAVTEJ. 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 Singh Johar. JOHAR. Navtej Singh Johar case 2018 in relation to section 377. Relation to section 377. Relation to section 377. Section 377. Section 370. So what had happened? Section 377 was being misused. Why? To target the LGBT community. That their certain actions were being criminalized. What did the Supreme Court say? That this law is arbitrary and therefore declared it to be null. Or they basically read it down that it cannot be used against the LGBT community. You get this contextually? Some Article 14 actually appears like every week in the newspaper because every week the High Court or the Supreme Court is declaring some law to be null and void or some executive action to be null and void. And what are they using to declare it to be null and void? 14. That they've used 14 to declare it that it is unreasonable classification, or they have said that it is arbitrary. Like if you see recently, Delhi introduced a policy for 15 years that the cars would have to be turned to scrap. They withdrew this immediately. But the point is, if it would have been continued, the first argument would be, is it reasonable? The second argument would be, is the policy of the Delhi government in itself arbitrary or not? And the court would have taken a view on this. This part is clear? Any doubts on this? All right, give a heading. Limitations. Limitations of reasonable classification, limitation of reasonable classification and in relation to arbitrariness, and in relation to arbitrariness, and in relation to arbitrariness. Arbitrariness. What happens if the question is asked in either of them? You can use the same points for both. Write down first, inconsistency in application. Inconsistency in application. Inconsistency in application. Inconsistency in application. Right. Second, leads to judicial overreach. Second point, leads to judicial overreach. Leads to judicial overreach. Judicial overreach. Third, violates separation of power. Violates separation of power. Violates separation of power. Next, risk of unjustified reasonableness. Unjustified reasonableness. Risk of unjustified reasonableness. Reasonableness. And write on the last one. Open to interpretation and subjectivity. 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 So these are same points that you can use both for reasonable classification and for arbitrariness. There is judicial overreach because what you're trying to do is declare a policy or a law that has been made by the legislature or by the executive to be null and void. So you're reaching into the executive sphere. Sometimes the policy might be necessary, but they're allowed to do this. They're allowed to do this under Article 14, that if any law violates a fundamental right, it would be declared null and void, provided under Article 13. 13 says that any law that violates fundamental rights can be declared null and void. So Supreme Court's view is it's not overreach. It's judicial review. But sometimes there is a case of overreach in these certain situations. So you write these points accordingly. There's no need to give examples in relation to them. Okay. Any doubts on this? Right on the next one. Significance. 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 Provides legitimate testing. Provides legitimate testing, provides legitimate testing, legitimate testing. So meaning the Supreme Court continues to ask, you show where how it is intelligible. You show how it is reasonable. Right on the next one. Enforces legislative, enforces legislative and executive accountability. Enforces legislative and executive accountability. 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 Safeguards individual rights. Next one. Safeguards individual rights and fundamental rights. Safeguards individual rights and fundamental rights. Fundamental rights. Upholds separation of power, separation of power in relation to Article 13. Upholds separation of power in relation to Article 13. Upholds separation of power in relation to Article 13. Article 13. Article 13. All right. So these are the significance, these are the problems. Any doubts right now? All right. No doubts? Just write down recent examples. So these are all the cases of 2024 in which it has been used. Right? Just recent example. First is Davinder Singh case. Recent examples. Davinder Singh case. Devinder. Davinder Singh case 2024. 2024. It was in relation to subcategorization of scheduled caste and scheduled tribes. So that is a topic that we'll also cover. So what happened is that in SC/ST, you did not have this concept of subclassification, which was done, and the Supreme Court said that it is reasonable. It is a reasonable classification. Right on? The Davinder Singh case in relation to SC/ST subcategorization. SC/ST subcategorization. Next is Sukanya Shanta case. Sukanya Shanta case. Sukanya. Sukanya Shanta. Shantha. Shanta case 2024. 2024. In relation to prison rules. In relation to prison rules. In relation to prison rules. In bracket, certain rules struck down under Article 14. Certain rules struck down under Article 14. Certain rules struck down under Article 14. Under Article 14. Under Article 14. So what had happened in the Shanta case is actually very important. Different states in India had different prison rules. And what had happened is that they still use caste as a classification. That the food for the Brahmins would be cooked by Brahmins only. Those that belong to criminal tribes in the past would be treated separately. That there would be a separate line, separate place to stay for them. And they would be made to do certain kind of jobs. So what had happened that these prison rules might have been made at a particular period of time, but they were continuing till date. Supreme Court actually struck all of them down. Some of the rules that were based on caste. This part is clear. In brackets, you can also write caste in relation to this. It's an important case, especially from like it can be asked. Yeah, in the state, in the prison rules. Everything goes unnoticed till the time that people realize. Like with the Waqf, that also happened. That it had so much land, it went unnoticed till the time it became in limelight. Same thing happened with the prison rules. A lot of people were saying for a long time that the prison rules were casteist. So there were a lot of academic articles and all of this. But nobody took notice of it till the time the Supreme Court declared it to be arbitrary. Like Brahmins would only be served by Brahmins. There would be a separate kitchen also for them. There would be a separate line also for them. People who belong to criminal tribes would be treated separately. They would have different living quarters. Whether those rules were being implemented or not, that's a separate case, but they were still in the prison rules. Finally, they've done this now. All right. Write down. Gaurav Kumar case. Gaurav Kumar case 2024. Gaurav Kumar case 2024. In relation to unequal fees, in relation to unequal fees in bar councils, unequal fees in bar councils, bar councils. So you have various lawyers when they file for an application to become member of the bar councils. What would happen is different states would have a different most recent ones. So up till date, I've made you write all of the cases that where it has been utilized, the major ones. Any doubts on this? No doubts? All right, write down then the next topic. Backward class. Backward class. Backward class. Where class still 3, 5, 2, 7. We have time. All right. Write down backward class. Backward class. So what happens is the term backward class is mentioned multiple times in the Constitution, Article 15, Article 16, and other places. We're going to study backward class from the perspective of Article 16, because it is in Article 16 that the backward class has been defined. It is under backward class that Indus Wani ended up saying that OBC reservation is fine. And there was a recent issue that happened with the Maratha reservation, with the Chart reservation and other aspects. That is why it is important in the news. Further, when you look at religion-based reservation, religion is not mentioned as a criteria for reservation. What happens is any religious community that is given reservation, that is also given under the category of backward class. So this issue that happened in Karnataka, this issue that has happened in West Bengal, all of these together, I'll make you write in one topic, because the overall question would be on backward class itself. Write down. Article 16 provides for equality of opportunity. Article 16 provides for equality of opportunity. Article 16 provides for equality of opportunity in public employment. In public employment. In public employment. In public employment. Public employment. Public employment. However, it allows for positive discrimination. However, it allows for positive discrimination, positive discrimination, positive discrimination, positive discrimination in the favor of residents, in the favor of residents, basically domicile, residents, scheduled caste, scheduled tribes, residents. I'll make you write all of them, then full focus on residents. Residents, scheduled caste, scheduled tribes, SEBC, socially and economically backward class, SEBC, socially and educationally backward class, EWS and EWS, economically weaker sections, EWS, economically weaker section, economically weaker sections. So what Article 16 says, that there would be equality of opportunity, but it allows for reasonable or positive discrimination. It ends up saying that the state will not discriminate on the basis of religion, race, caste, sex, descent, place of birth, and residence. That you cannot discriminate against anybody on any of these criteria. But then you have exceptions. The first exception is actually residence. That you can discriminate on the basis of residence. That is why you have domicile-based reservation in India. That at least 85% of the seats in almost every state PCS is basically reserved for domiciles. That's why when you give HPSC, Haryana Public Service Commission, or UPPCS or RPSC, about 85% of the seats would always be reserved for the domiciles of that state. So that is the first exception. The next exception is made for scheduled caste, scheduled tribes, backward classes, and the proper term for backward class is actually SCBC. Where is it? Backward class. Socially and educationally backward class. And for economically weaker sections. This part is clear to everyone? Write down. Criteria for determining, give a heading, criteria for determining backward class. 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 Backward class. Backward class. So within the constitution, the word backward caste is not mentioned anywhere. It's not supposed to be backward, or OBC. OBC is other backward caste. That is not mentioned. What you have is the term backward class. OBC is a classification under backward class itself. There are multiple classifications under backward class. Write down. The term backward class, the term backward class, the term backward class is not confined to only mean caste. To only mean caste. To only mean caste. To only mean MEAN caste. Caste. In the M.R. Balaji case, in the M.R. Balaji case, 1962. In the M.R. Balaji case, M.R. Balaji case, 1962. 1962, the Supreme Court held that caste cannot be the only or predominant factor to ascertain ascertain whether to a certain backwardness. Next one, the Supreme Court in the R. Chitralekha case. The Supreme Court in the R. Chitralekha, CHITRALEKHA, R. Chitralekha case, CHITRALEKHA, 1964, explained the meaning of class. Explain the meaning of class. Meaning of class. It is a group of person having common attributes. It is a group of persons having common attributes coupled with social backwardness, and lack of economic and educational development. Economic development. Write on the So what happens is, if this is asked then in the UPSC, you end up saying that what is the criteria? The criteria is that in the Chitra Lekha case, the Supreme Court has ended up saying that the criteria are these 3 points. You have social backwardness, you have economic weakness, and you have intellectual backwardness. Actually, the word that the Supreme Court ended up using was retarded. But the point is, now you can't use the word retarded. Within the UPSC examination, they ended up saying intellectual retardedness. But what you end up saying is educationally backward. Why? Because the word retarded is now not used in the UPSC. At least you don't use the word there. So it ended up laying these 3 criteria. Article 16, write down separately. Article 16 also lays the criteria, Article 16 also lays the criteria of those that are not adequately represented. Of those that are not adequately represented. Not adequately represented. Not adequately represented. So overall, now you have 4 criteria. And these are the 4 criteria that the Supreme Court generally uses to decide whether you're backward or not. They would look at whether you have social backwardness or you have been historically socially discriminated, economic backwardness, educational backwardness. Further, are you not adequately represented in government services? So this was used during the Jat reservation and also during the Maratha one. That you do not end up fulfilling this criteria. That neither the Jats nor the Marathas fall under this category. Further, the Supreme Court has ended up saying that caste cannot be the only criteria. It can be one of the criteria, but it cannot be the only criteria. That when you say social backwardness, fine, we'll acknowledge caste in that particular aspect. But it cannot be the only criteria. You need to have others. And within the caste also, you need to also show that you were historically discriminated. This part is clear to everyone, right? Write down. Separately, the Supreme Court, in the Indira Sohani case, 1992, the Supreme Court in the Indira Sohani case, 1992, ruled that while religion, race, caste, and other group identities were relevant, they cannot be the sole criteria. For granting reservation. They cannot be the sole criteria for granting reservation. Granting reservation. It upheld 27% reservation for OBCs. It upheld 27% reservation for OBCs with certain conditions. It upheld 27% reservation for OBCs with certain conditions. Certain conditions. So in brackets, 50% ceiling. Just write down the conditions. All of you already know them. 50% ceiling on reservation, except in extraordinary situation. Right? Ceiling of 50%, ceiling, CEILING, ceiling of 50% on reserved quota, which is to be exceeded under extraordinary situations. Under extraordinary situations. under extraordinary situations. Like one example of this is Arunachal Pradesh. Arunachal Pradesh is 99% roughly scheduled tribe. So you cannot have the scheduled tribe reservation, which is 7.5%. So for them, they have exceeded 50%. The reservation that has been provided for scheduled tribes and would not be a problem. So you have to showcase extraordinary situation. That also becomes a reason why the Supreme Court turns down the Jat and the Maratha reservation, that there is no extraordinary situation with these communities. That even if you want to exceed reservation. Right on. It several also laid down several social, economic, it also laid down further social, economic, and other factors to determine OBC status, to determine OBC status, to determine OBC status, OBC status, OBC status, OBC status. And write down the last point. The Supreme Court in the Ram Singh case 2015, the Supreme Court in the Ram Singh case 2015, Ram Singh case 2015, for Jats, in relation to Jats, in relation to Jats, in relation to Jats in Haryana, Jats in Haryana, and in the Jaishri Patil case, and in the Jaishri, 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 Jaishri Patil case 2024, Jaishri Patil case 2024, Jishri, Patil Patil case 2024, in relation to Marathas, Marathas invalidated the reservation for these communities, invalidated the reservation for these communities, invalidated the reservation for these communities, for these communities. Right. That is the example you end up writing. So you have the idea of a backward class. This idea of classification in a backward class, when you talk about in the Chithalekha case, so you have three factors here, and you have one factor in Article 16, reasonable classification. So if you provide anyone with, let's say, backward class status, you have to show that it is reasonable also. You have to show that the nexus with the objective also. And this was not been able to done with the Jats and the Marathas. This part is clear to everyone? This is the same problem that happened with the religion-based reservations within Karnataka and West Bengal. That you can also provide. So you have said that caste is not the sole criteria. Under backward class, you can provide reservation on the basis of religion also. So that is what has happened, is that in Karnataka, the problem happened is that you basically gave almost all Muslims backward caste status. And the court was like, how can that be possible? How can everyone be backward? There has to be forward caste, there has to be backward caste. West Bengal also gave classification, but they actually did make a difference that these are forward caste, these are backward caste among Muslims. But the Supreme Court's view was, the ones that you have said are backward caste, what is the survey? What is the intelligible survey here that I can see that these have been historically discriminated, these have educational backwardness, these are not adequately represented. So go and conduct a survey, and then we'll talk about that reservation. This part is clear to everyone? Any doubts on this? All right. No doubts? Survey to see this. So what happens is, I'll give you an example. What has happened is that during 2017, 26, actually during this period of time, you saw a lot of caste agitations where the Jats were asking for reservation. You had the Reddis in Hyderabad asking for reservation. You had the Lingayats in Karnataka asking for reservation. The Patidas in Gujarat were asking for reservation. The Marathas in Maharashtra were asking for reservation. All of them stopped because of the Ram Singh case. Because none of these communities can fulfill this criteria. If you look at the Lingayats also, if you want to give the Lingayats reservation in Karnataka, you would have to first showcase that they have been historically or social backwardness, that they have been historically discriminated. You have to show that they're educationally backward. You also have to show that they are um, economically backward. For these two, you would have to conduct a survey. After this, you have made the criteria, you also have to showcase under Article 16 that they are not adequately represented in the state services. So you have to carry out a survey how many Reddis or Lingayas are there in Karnataka services. After this, you make a classification that this is the percentage of reservation that would be given to the Lingayats under OBC. Then it goes to the Supreme Court, and Supreme Court sees whether this is done or not. With the Marathas, the problem happened is the survey was, with the Jats, the problem happened, the survey was also not done. With the Marathas, they also did a survey, but the Supreme Court said, with the survey also, it does not seem like they are backward. You get this? Same thing if you're trying to do this on the basis of religion, that there are certain Muslim communities that are also in the backward class list of the central list. So the basic idea of the government is that you take the Sayyids, you take the Khans and all of this forward caste. But you have Mali and other type of caste among Muslims that would be considered as backward class or backward caste. This part is clear to everyone? Any doubts? All right, right on the next topic. You're kind of tired, I can see. But we have to go through. I won't. You have? I also have morning classes. 7:30. Exactly the same time. We start at the same time, which is being given. Class timing is 7:15. They have decided. All right, you do just write down the topic, and we'll do it tomorrow. All right, try down. Prior restraint. Prior restraint. PRIOR. Prior restraint. 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 Prior restraint. So just I'll just show you once. It's not there. So what has happened is sometimes you see in the news of gag orders being put. Like Adani ended up putting a gag order or got the court to put a gag order in relation to a journalist of news laundry. Similarly, a gag order was put also on Ranveer Alabadia. The actual concept is known as prior restraint. What you have done is said that a person cannot have freedom of speech and expression. You have stopped them from talking itself. So there is a prior restraint. What generally happens is an action is taken. If the action violates, then you're punished for it. But what is happening is that you have been asked to not speak in the first place. This is not allowed in India, especially after emergency. Because during emergency also, Indira Gandhi's government ended up asking the newspapers and others prior restraint. That you do not say this, you do not say that, you do not talk about this, you do not criticize the government, you do not criticize what is happening during emergency. This is censorship. But Supreme Court, I'll make you write what the Supreme Court view is, that prior restraint in India can be done. But it has to be done in very limited cases. But that is now on how it is functioning. So under Article 19, there are 3 topics: prior restraint, hate speech, and um, sedition. All of that we'll end up talking about. So the next topic we'll do next week would be prior restraint. Any doubts? No doubts? All right, those who want to show me the answer, you show me. After the class, just one more thing. You write down a question also, and you show me the answer accordingly. Right? If you see this question, a legislation, everyone just, I know, 2 minutes just. A legislation which confers on the executive or administrative authority unguided, uncontrolled discretionary power in matters of the application of law violates which one of the following articles? Because we've done. What is this? If you put this in one line, what is it? Arbitrariness. This is what the Supreme UPSC has also asked in one of the previous prelims examination. So it can be asked in the mains examination also. That this is basically arbitrary. Right? It violates Article 14. So write down the question. Article 14, Article 14, Article 14, Article 14 strikes at unguided and uncontrolled discretionary power of the executive discretionary power of the executive. Full stop. Comment. 150 words. 150 words. 150 words. All of you have my number. If you have a doubt, you can ask me on WhatsApp. Those students that are online, they're sending me answers on WhatsApp also. So if any of you want to send me answers on WhatsApp, I'll check it and I'll send it back to you. Otherwise, we'll probably meet next week whenever the class of polity would be there. Right?